facing the police every single day.
You get the whole thing.
Say hi, Andy. I'm recording you.
All right, you get the whole thing. Right?
I got you.
Ocean City cops are not people.
Yes, they are. You know what's really criminal?
What's that?
Those knee-high socks.
I know, but that's what the brown shirts wore.
Commonwealth of Massachusetts. Suffolk, SS Superior Court Civil Action No. Michael Picard and Heidi Olson, Plaintiff, v. Massachusetts Department of Conservation and Recreation, Massachusetts, State Police, and Devin Surian, in his capacity as a Massachusetts State Police trooper and, in his individual capacity, defendants. Verified complaint for declaratory and injunctive relief and relief in the nature of certiorari. Introduction 1. This is a civil rights action challenging the constitutionality of Department of Conservation and Recreation, DCR, regulations that unlawfully restrict rights to free speech and expression on public lands and that were applied to plaintiffs on November 11, 2021. 2. On November 11, 2021, plaintiffs engaged in a peaceful counter-protest in support of gay rights in response to a demonstration in Lynn, Massachusetts involving at least one person who had previously made statements in public and posted them online that plaintiffs perceived as homophobic. 3. Plaintiffs' counter-protest was completely peaceful and consisted primarily of holding a sign saying, "Let's make everybody gay," soliciting signatures for petitions in support of gay rights, and advocating for a pride flag to be hung along with other flags being erected by the 1. Demonstrators on the seawall. At times, plaintiffs used bullhorns to ensure their voices could be heard. 4. In response to this peaceful and satirical counter-protest, Massachusetts State Police, MSP, Trooper Surian ordered plaintiffs to stop using bullhorns and to leave DCR property and then issued citations against them. DCR then failed to provide plaintiffs the due process required under its regulations to challenge citations for conduct on DCR-operated property. 5. Plaintiffs seek declaratory and injunctive relief as to the constitutionality of the DCR regulations on which the citations and Trooper Surian's actions against them were based, the legality of Defendant Surian's actions against them on November 11, 2021, DCR's failure to afford plaintiffs the administrative hearing process required by law, and MSP's failure to respond timely to a related public records request. Parties. 6. Plaintiff Michael Picard resides in South Windsor in Hartford County, Connecticut. 7. Plaintiff Heidi Olson resides in Gloucester, in Essex County, Massachusetts. 8. Defendant The Department of Conservation and Recreation, DCR, is an agency of the Commonwealth of Massachusetts with headquarters in Suffolk County, Massachusetts. It is responsible for management of the Lynn Shore Reservation and the property on which the events of November 11, 2021 occurred. 9. Defendant The Massachusetts State Police, MSP, is an agency of the Commonwealth of Massachusetts with headquarters in Middlesex County, Massachusetts, and a barracks in Suffolk County, Massachusetts, to which, upon information and belief, Trooper Surian is assigned. MSP provides policing services on DCR-managed properties, including the Lynn Shore Reservation. 2. 10. Defendant Devin Surian is an officer/trooper employed by MSP, assigned to the MSP Revere, Massachusetts barracks, and who resides in Suffolk County, Massachusetts. 11. This court is an appropriate venue for this action challenging the regulations and actions of a division of the state, pursuant to GLC 223(1) and GLC 66, 10A, C, and because DCR's headquarters and the MSP barracks to which Trooper Surian is assigned are in Suffolk County. Facts. The counter-protest. 12. On November 11, 2021, a group of people staged a demonstration near a sidewalk along Lynn Shore Drive in Lynn, Massachusetts, on public property that is managed by DCR. 13. These demonstrators included individuals who regularly demonstrate in the area, including in support of former President Trump and in opposition to President Biden, including by calling out to passers-by "Fuck Joe Biden." On November 11, 2021, they affixed flags to the seawall that runs alongside the water and next to the sidewalk that is part of the reservation. The flags contained messages supporting former President Trump, U.S. troops, and gun rights. 14 plaintiffs knew that one or more of these demonstrators had previously participated in demonstrations in which they expressed views that plaintiffs considered homophobic and offensive, including with regard to an LGBTQ+ flag flown at Swampscott Town Hall. For instance, a few days before November 11, the organizer of the November 11 demonstrators called out to someone displaying the LGBTQ+ pride flag that they were trying to make everybody gay and to make the kids gay. She called out to someone, "Take down the gay flag, faggot." Based on her own social media postings, a few days before that, she told a passerby who objected to her comments that he was a stupid faggot, that she had pepper 3. spray and yelled, "Do you want it?" and told him to tell them to take down the gay pride flag, faggot. In addition, this same person posted footage of herself apparently on a different day, in which, after taunting young boys at a school in Swampscott who did not want to talk to her, she said that the schools were trying to turn boys into girls, fags, gay. 15 On November 11, 2021, plaintiffs arrived together at the location of the demonstration to counter-protest this group of demonstrators. 16 Plaintiff Michael Picard carried a handmade sign saying, "Let's make everybody gay." He politely greeted the organizer who had made the anti-gay comments referenced above. He asked her if she would support a petition to put LGBTQ flags every 20 feet in Swampscott and Lynn. In response, she threatened to pepper spray him as shown on her own recording of the event. At times, he asked people if they wanted to sign a petition in support of gay rights. 17 Plaintiff Heidi Olsen asked the demonstrators to put up a pro-LGBTQ+ pride flag and called for passers-by to encourage them to do so. 18 plaintiffs each maintained distance between themselves and the other demonstrators and periodically used bullhorns that were not discernibly louder than the voices of the demonstrators. They did not impede anyone's passage on the public sidewalks or grass. They were calm and pleasant in the face of anger coming from some of those they were counter-protesting. 19 Soon after plaintiffs arrived, at least one of the demonstrators used a bullhorn, including to amplify the sound of a siren directed at plaintiffs. 20 Upon information and belief, one of the original demonstrators called the police in response to plaintiffs' presence. MSP officers, led by defendant Surian, soon arrived and began talking to participants. 4. 21 Defendant Surian first told plaintiffs they could not use bullhorns without a permit, which they promptly agreed to stop using. 22 Defendant Surian then told plaintiffs they had to leave the area entirely because they did not have a permit. At one point, he also told the original demonstrators that they could not protest on DCR property without a permit, but then allowed them to remain for over an hour. 23 Defendant Surian then told plaintiffs they were not free to leave until they provided their names and contact information in conjunction with using the bullhorns. 24 During these interactions, Defendant Surian told one of the demonstrators that he knew the plaintiffs were engaging in conduct that was inciting, presumably referring to the fact they were engaging in a counter-protest that the demonstrators did not appreciate. 25 After Plaintiff Picard left the area and returned, Defendant Surian told him that if he did not leave the area, he would issue another citation against him. Prior proceedings. 26. A few days after November 11, plaintiffs received citations in the mail for allegedly violating the regulation for amplified sound device use of without a permit. Sic. See Exhibit A, Picard citation, and Exhibit B, Olsen citation, home addresses redacted. 27 2 DCR Regulations, 302 CMR 12.04, 28, E, the Audio Device Regulation, and 302 CMR 12.04, 28, F, the Public Address System Regulation, require advance special permits on public lands for use of certain audio devices or public address systems with no objective standards to guide enforcement discretion and which do not clearly apply to mere bullhorns. 28 These regulations were not cited in the citations plaintiffs received. The only regulation cited in each citation was the Disorderly Conduct Regulation, 302 CMR 12.04, 4. 5. 29 302 CMR 12.04, 4, prohibits disorderly conduct on DCR-operated public properties, which is defined to include unnecessary noise offensive to the general public, with no objective standards to guide enforcement, as well as use of profanity, vulgar or obscene language, or other language that may incite fighting or harm to DCR personnel or to the public. 30 Each citation was on a DCR citation form and indicated each plaintiff was being fined $200 for the asserted violation. 31 Each citation also said, if you desire to contest this matter, you may do so by making a written request for a non-criminal hearing, enclosing a copy of the citation, and mailing to the address below within 21 days of the date of this notice. 32 Upon information and belief, neither the demonstrator who threatened to pepper spray plaintiff Picard nor the demonstrator who used a bullhorn were cited for their conduct. 33 Plaintiff Olson requested a hearing from DCR by promptly sending a request to DCR in the pre-addressed envelope that came with the citation. On November 23, 2021, Ms. Olson received a letter from DCR informing her that her only avenue for challenging the citation, and purportedly avoiding criminal prosecution, was to seek relief from the Lynn District Court. Exhibit C-34. Contrary to the DCR letter, pursuant to 302 CMR 12.21, a party who is aggrieved by a DCR decision may appeal such decision in writing within 30 days. Appeals to DCR decisions will be conducted in accordance with MGLC.30A and the regulatory provisions found at 801 CMR 1.00, Standard Adjudicatory Rules of Practice and Procedure. 35 In reliance on DCR's communication, both plaintiffs sent materials to the Lynn District Court saying they wanted to appeal their citations. In response, hearings were scheduled by 6. The court pursuant to GLC 40:21D, even though on its face that statute applies only to actions taken pursuant to municipal laws, not regulations of state agencies. 36 On December 11, 2021, Plaintiff Picard submitted a public records request to the Public Records Officer at MSP, seeking all records and recordings related to the November 11, 2021, incident. A copy of that request is attached as Exhibit D. He never received any response, let alone within 10 business days, in violation of GLC 66:10. 37 As a result of MSP's failure to comply with the public records law, plaintiffs did not have access to the police report, and other documents related to their citations, which hampered their ability to prepare for the appeals of their citations. 38 On March 14, 2022, purportedly pursuant to GLC 40:21D, a proceeding was held by a clerk magistrate in the Lynn District Court as to the citations against both plaintiffs. Both plaintiffs submitted arguments for why the citations could not lawfully be sustained, but the clerk magistrate nonetheless purported to uphold them. Exhibit E, Olson, and Exhibit F, Picard, plaintiffs' home addresses redacted. Upon information and belief, no application for issuance of a complaint against either plaintiff pursuant to the 7th paragraph of GLC 40:21D has been made by DCR or MSP, but the threat of further enforcement action remains. 39 On March 30, 2022, Counsel for Plaintiff Picard alerted Counsel for MSP to the issue of MSP's failure to respond to Mr. Picard's public records request. To date, MSP has still not produced any of the documents responsive to the December 11, 2021 public records request. 40 Both Plaintiff Olson and Plaintiff Picard intend to protest and/or counter-protest in the future on DCR-operated property. They fear their free speech and due process rights will again be 7. Curtailed as a result of the challenged regulations and processes applied to them in connection with their November 11, 2021 counter-protest. Causes of action. Count 1 Free Speech and Expression Article 16 of the Declaration of Rights and First Amendment to the U.S. Constitution. 41 The foregoing allegations are incorporated herein. 42 The disorderly conduct regulation is unconstitutional on its face because it is content-based, not narrowly tailored to achieve a significant or compelling governmental interest, is overly broad, and does not contain standards to guide discretion or give adequate notice of what is proscribed. 43 The audio device and public address system regulations are unconstitutional prior restraints on speech that cannot be justified, and are facially unconstitutional because they are overly broad, are not narrowly tailored to achieve a significant governmental interest, and do not contain standards to guide permitting discretion or give adequate notice of what is proscribed. 44 Trooper Surian's actions on November 11, 2021, with regard to the plaintiffs, including but not limited to the order to cease using bullhorns and the order to leave the area, and the issuance of the citations against plaintiffs are unconstitutional applications of the regulations. 45 The disorderly conduct regulation, the audio device regulation, and the public address system regulation, facially and as applied to plaintiffs, violate Article 16 of the Declaration of Rights, as amended, and the First Amendment to the U.S. Constitution. 8. Count 2 Due Process Article 10 of the Declaration of Rights and 14th Amendment to U.S. Constitution. 46 The foregoing allegations are incorporated herein. 47 The disorderly conduct regulation, the audio device regulation, and the public address system regulation are unconstitutionally vague on their face because they fail to give sufficiently clear notice to those potentially subject to them as to what is prohibited, and fail to provide sufficient standards to guide enforcement or permit granting discretion, particularly with regard to matters of free expression. 48 The regulations failed to give plaintiffs sufficient notice that their conduct on November 11 was unlawful and therefore are unconstitutionally vague as applied to plaintiffs. 49 The actions of Trooper Surian and the citations, which rely on the challenged regulations, are unconstitutional violations of Article 10 and the 14th Amendment. 50 In addition to the foregoing, DCR has denied plaintiffs the process they are due by failing to afford them an adjudicatory hearing as required by 302 CMR 12.21 and instead directing them to challenge the citations in district court pursuant to an inapplicable statute. Count 3 DCR failure to follow its own regulations certiorari GLC 249, 451. The foregoing allegations are incorporated herein. 52 302 CMR 12.21 provides that a party who is aggrieved by a DCR decision may appeal such decision in writing within 30 days. Appeals to DCR decisions will be conducted in accordance with MGLC 30A and the regulatory provisions found at 801 CMR 1.00, Standard Adjudicatory Rules of Practice and Procedure. 53 In spite of this language, DCR denied plaintiffs the right to a DCR adjudicatory hearing and instead indicated their only avenue to appeal was through the district court pursuant to GL. 9. C 40, 21D, even though on its face GLC 40, 21D does not apply to citations issued pursuant to state laws or state agency regulations. 54 DCR's failure to comply with its own regulations is unlawful. Count 4 Massachusetts Civil Rights Act GLC 12, 111, as to Trooper Surian in his official and individual capacities. 55 The foregoing allegations are incorporated herein. 56 By his conduct on November 11, 2021 at the Lynn Parkway, and in issuing the citations against plaintiffs, Trooper Surian interfered and/or attempted to interfere with plaintiffs' rights to free speech and due process, protected by Article 16 and 10 of the Declaration of Rights and the First and 14th Amendments to the U.S. Constitution by means of threats, intimidation, or coercion, including by explicitly and/or implicitly threatening to cite and/or arrest them if they did not cease their expressive activities, provide their names and addresses, and leave the public lands on which they were lawfully present. Count 5 Massachusetts Public Records Law GLC 66, 10A, C, as to MSP. 57. The foregoing allegations are incorporated herein. 58. Plaintiff Picard made a valid public records request pursuant to GLC 66:10. 59. MSP failed to respond to that request as required by law within 10 business days of plaintiff's request. Prayers for relief. Plaintiffs Michael Picard and Heidi Olsen hereby request the following relief. 1. A temporary restraining order directing defendants to take no further action to enforce or collect the $200 fines purportedly levied against plaintiffs, including but not limited to any 10. Action to initiate criminal process in connection with the fines or any further action contemplated by GLC 40:21d, pending resolution of this litigation. 2. Issuance, after specific request by counsel for plaintiffs, of a short order of notice as to plaintiff's request for a preliminary injunction. 3. After hearing, issuance of a preliminary injunction against defendants taking any further efforts to enforce or collect the $200 fines against plaintiffs, and against continued enforcement of the disorderly conduct regulation, the audio device regulation and/or the public address system regulation against plaintiffs, with regard to free speech/expressive activities, pending resolution of this litigation. 4. A declaration that the disorderly conduct regulation, the audio device regulation and the public address system regulations are facially unconstitutional with regard to expressive activities, and unconstitutional as applied to plaintiffs' conduct on November 11, 2021, both as a matter of free speech/expression and due process. 5. A declaration that the November 11 citations cannot be justified by reliance on the audio device or public address system regulations because they were not cited in the citations given to plaintiffs. 6. A declaration that Trooper Surian violated Article 16 and the First Amendment by ordering plaintiffs to cease using their bullhorns and to leave public lands on November 11. 7. A permanent injunction against defendants with regard to continued enforcement of the disorderly conduct regulation, audio device regulation and/or public address system regulations as to any expressive activities by plaintiffs. 8. A declaration that DCR has failed and is failing to meet its obligations under 302 CMR 12.21 by not providing an adjudicatory appeal process as required by that regulation with 11. Regard to appeals of citations, fines and other enforcement actions pursuant to DCR regulations. 9. A declaration that the District Court did not have in this case, and that the District Courts or other courts of the Commonwealth generally, do not have jurisdiction under GLC 40:21d to hear appeals of citations of alleged violations of DCR regulations. 10. A declaration that Trooper Surian violated the Massachusetts Civil Rights Act by his conduct toward plaintiffs on November 11, 2021. 11. A declaration that MSP failed to comply with the Massachusetts Public Records Law with regard to Plaintiff Picard's December 11, 2021 request and as reasserted on his behalf on March 30, 2022. 12. An award to plaintiff's attorneys of attorney's fees and costs pursuant to GLC 12:11I, GLC 66:10A, and 42 U.S.C. 1988, 13. Such other and further relief as this court deems just and proper. On behalf of plaintiffs Michael Picard and Heidi Olsen. Ruth A. Borquin, BBO number 552985, American Civil Liberties Union Foundation of Massachusetts Incorporated. 1 Center Plaza, Suite 801 Boston, Massachusetts, 02018617482-3170, extension 348 R. Borquin@aclum.org. Naomi R. Schatz, BBO number 677637, Zalkind Duncan and Bernstein LLP 65A Atlantic Avenue, Boston, Massachusetts, 02110617742-6020 nshats@zalkindlaw.com. 12.
Stop, here we go.
No. Put this guy in. You gotta leave.
No.
You gotta leave. You're leaving.
No.
You're leaving.
No.
This guy's causing trouble here. This guy's causing trouble. You gotta leave.
are you touching me?
You can't be running around all crazy though, man. What are you doing?
Why are you touching me? Why are you touching
Bro,
me?
you just gotta go, man.
No.
Bro, chill. Chill. Gotta go, my friend. Gotta go.
Tell them to get their hands off.
Gotta go. Gotta go.
Excuse me. I converted on the target.
I'm sorry, but you are not welcome.
Can I tell you a secret?
Sure.
Chill.
You good?
It's been a while. Hey,